Okay. Afternoon, everybody. My name's Phil Edwards. My colleague Hilary Wetherell's with me. We are going to talk in a different context to the talk that you've just heard, in the sense that we're not going to be dealing with the technical issues of the rules, but we're actually going to be talking to you, trying to keep in accordance with the theme of the day, about working in partnership, working together in terms of getting the best outcome for our clients. And I sort of wanted to start by saying the programme for today, I think this is wonderful, by the way, the people that developed that, it's a fantastic image, it really is brilliant. There's one professional on there that's often involved that's not on there, and that's the lawyer. And I'm sure all of you in your practices will know that you have individuals that have compensation claims ongoing, they have lawyers involved. Often two lawyers, because there'll be the lawyer acting on behalf of the claimant, there'll be the lawyer acting on behalf of the defendant, but they are involved in the process. It's not altogether surprising we're not on there. One of the things that I think the legal profession is secretly quite glad about is the credit crunch, simply because bankers are now more unpopular than we are, which has never been the case for quite some considerable period of time. What we're going to do is take you through in very broad terms how the litigation works. We're going to go through that quite quickly because that's not really the point of the talk. We've also got a couple of case studies to demonstrate how things have worked in practice for the benefit of clients. Again, certainly one of those we'll go through very quickly indeed, because we're quite keen to actually generate some discussion and debate around one or two bits and pieces in this. Start actually by saying, well, what are the shortcomings of our system? Well, of course, we're only involved where liability can be established. Again, I'm not going to give you a lecture on the law of common law negligence or breach of statutory duty. In broad terms, we're talking about lawyers being involved when someone else is at least partly to blame for what's happened to the individual who sustained the injury. That means there's a whole cohort of people out there who quite properly haven't got claims. We don't have a society like sometimes happens in Australia to a degree, New Zealand, in other places where it's a sort of state-based compensatory system. We are a fault-based compensatory system. Clients may be partly to blame for accidents. They may also be contributory negligent. And the way that works is if a client is partly to blame, then the total level of damages that they'll receive will be reduced by that percentage of blame. Okay? That means that they're not going to have the money that they need to fulfill all of their compensatory needs. It's just not going to happen. So one of the things that I think is often said, particularly about the lawyers on behalf of the claimant, is that we ignore statutory provision. We don't want to engage with it. We think it is the enemy, the last thing we want. All that's going to do is mean that provision's going to be provided to our clients in a way that means the total damages are going to be less because the defendants aren't going to have to pay for it. System, again, isn't as simple as that, but it's also wrong. We will often be engaging with statutory services, with the NHS, with social services, with all sorts of different bodies, with voluntary services at times, in order to make sure that the client gets the full range of services that they need. That applies up until liability is admitted and very often beyond. The purpose of compensation is important, and again, this is just the scene setting for what I'm going to come on to. We have a pretty much exclusively compensatory system. What that means is that the level of damages that an individual receives is only designed to compensate them for their losses, to put them back in the position they would have been in but for the accident, as best money can. We all accept there's limitations to that. If you read stories from across the pond, the most famous one was the McDonald's coffee cup case where people were receiving millions and millions of dollars for relatively minor burns. That's for two reasons. One, the jury over there assesses damages. It's not done by a judge in accordance with guidelines. Secondly, they will often have elements of punitive damages. So it'd be more about punishing the wrongdoer than it is about compensating the individual who's been hurt. So if we get our job right and we do it right, our client is only getting what they need, not more than that. And that does mean that there are perhaps greater restrictions than people might otherwise think who aren't familiar with the legal process. Compensation also has to be reasonable. It might be perfectly reasonable to say this individual needs single-storey accommodation. Variety of mobility issues, we must have single-storey accommodation. It's probably unreasonable to say, and they like the warm weather, can we have it in Barbados, please? We're not going to get that. It has to look at the background to the situation, what the client had before, restoring the quality of life, but in a reasonable way. Time frames and delay, just to again, hopefully clear up a myth here, particularly in serious injury work, particularly in brain injury work, claims can go on for a long period of time. If it's a child brain injury, it can very often go on for years and years. But there's good reason for that. It's not the case that the legal system is slow and cumbersome. It's much, much better than it used to be, certainly 10 years ago, and a million times better than it was 20 years ago. What is happening more and more in the serious cases is the judiciary are getting to grips with the fact that it's appropriate to wait until the future is reasonably certain before actually finalising the case. Again, we all know it's never going to be absolutely certain. None of us have got that crystal ball that will tell us everything, but we need to be reasonably certain. So the judiciary will allow the case to develop over time such that an individual's given an opportunity to access rehabilitation and see how they get on, to attempt to return to work. As said at the bottom, in one sense, in our process, if we look at it in isolation, we have a little bit of a luxury in saying, well, we can have a bit of trial and error here, because we can actually support the client, the professionals support the client, we can provide the mechanism that they do that, and see how things go. If it's working, that's wonderful, it can move on to the next stage in the goal setting. If it's not, then the professionals can have a look at it again. When do lawyers get involved? Well, from our perspective, we'd say as soon as possible. There's lots of reasons for that, because the sooner we get involved, the sooner we can engage with the insurance company for the defendant. We can see what their attitude is to liability. If it's admitted early, as it often is in appropriate cases, we can start talking to them about interim payments, which can then start accessing some of the things we're going to talk to you about. If there's a genuine dispute on liability, that can happen. There can be differing views. Again, the earlier we're involved, the earlier we can bring that issue to resolution. We can actually say to the court, can we just have a trial on the issue of liability, please? We don't want to talk about damages yet. We don't want to talk about money. We just want to work out whether our client's going to be entitled to anything. And again, if we win on that, then we can talk to the defendants about interim payments and start accessing things. It's very important, we feel, for lawyers in this field to have experience of the whole range of professionals, the whole range of serious injuries involved. To give you some horror examples of things we've taken over, I've had a case whereby another lawyer was dealing with it. There was clearly a traumatic brain injury. It was very obvious to anyone. That lawyer sent the client off to an orthopaedic surgeon. The logic was, there's a depressed fracture of the skull's a bone. I'll have an orthopaedic surgeon's report, please. And bless him, the orthopaedic surgeon did his best and actually wrote back and said, this is all well and good, but I think you need a whole range of other experts. But at that point, the lawyer didn't really want to know. And I think when we're dealing with this, and if we, as part of what we want to say to you today, is we'd like to persuade you that actually having the lawyers involved in your teams as professionals is a good thing for the client. Consequent thing on our part is we need to know what we're talking about, and we need to be able to add value to that team, not actually become an obstacle. One of the ways we do that, we very much welcome it when we're invited to MDT meetings. It's invaluable for us in gaining information about what's going on. We also hope that it will become invaluable for you as well. One of the things that was spoken about this morning was very much about using things in the private sector to supplement what can be provided through the NHS or through social services. Well, if we know that interim payments are available and we come to those meetings and you can tell us in your professional expertise, well, do you know, we could really do with a particular form of therapy or more therapy than we're able to access in a particular way, or whatever it might be, then from our perspective, the sooner we know that, the better. Some law firms, ours included, have started to employ people, we call them CLMs, client liaison managers, who aren't lawyers. The lady who works with me in my office is an occupational therapist. She works for my firm, and she will go to a lot of these meetings because that's her area of expertise and experience. And she can bring added value because she will understand what's going on in that setting very well, but equally will then be able to link in with us as the legal team to work out how best we can work in partnership to deliver things for that client. There's a few practical things I wanted to tell you, and this is really the meat of what we want to talk about, rather than just the overview of the way the compensation system works, about ways in which this can be delivered for clients in a positive way. One of them is the Rehabilitation Code of Best Practice. This was brought in some years ago now through a joint initiative through the Association of Personal Injury Lawyers and the Federation of Insurance Lawyers, so both sides of the profession. What it was designed to overcome was any sort of instinctive suspicion of the other side, where it may be that the defence team were thinking, are the lawyers really going to grasp the rehabilitation issue, or are they not going to want to be interested in that because it will mean more damages? The claimant side would be thinking, if the defendants control this, all they're really going to do is to get a series of reports that say everything's going to be fine, and it may not be for this particular client. And what this does is it tries to take the sting out of that. It's voluntary. Both sides have to agree to it. If they agree to it, it means that the report that is produced, and it's supposed to be an immediate needs assessment report, it's designed to cover a limited period of time, is taken wholly outside of the litigation process. So it can't be referred to, can't be disclosed to anybody in the litigation process, and even the person who writes it. So the person, and that can be a variety of different professionals depending on the needs of that client, is not what we call a compellable witness. They can't be called to court to give evidence about it. There's limitations to it. There's whatever the recommendations are, there's no obligation on either party to engage in them. There's certainly no obligation on the insurance company concerned to say, yes, we'll pay for all of that. But in certain circumstances, that's a very useful tool in getting support to a client through the litigation in circumstances where perhaps some years ago inherent suspicion might have made it very difficult. There's also a BSRM protocol about the interface between the litigation and the rehab process or the medical process. I'm sure it's still available on their website if you go and have a look at that. This is quite a useful document because it was also recognised that sometimes what could happen is those of you involved in supporting people through the NHS process or the social services process might find lawyers coming along who would want to exercise some degree of control, would want to have a focus on the litigation and be saying, well, actually, in my client's litigation, it will be better if we do certain things which may not fit with the plans that the professionals on the ground had got. Well, what the protocol does is it provides a framework of best practice as to how to manage that interface. And some of the key highlights of that from your perspective are, number one, it provides primacy still to the NHS clinician who's leading it, not to anyone else. It provides a mechanism by which the lawyers should adopt so that if we are obtaining reports within the litigation from experts, there's a mechanism to feed those through to the people responsible for the support through the NHS or social services for them to consider. And then there's a mechanism for discussion between the legal team and the clinicians or the therapists or whoever's primarily responsible for looking after that individual. And to my mind, it represents an excellent way of making sure that this approach on a team basis works, because it's designed to put the client at the centre of it. And to look at what the client wants to achieve and how best to support the client. I'm going to move on quite quickly because I know we're running out of time a little bit. One thing sometimes people think about the legal process is that there can often be a reluctance for the lawyers to even want rehabilitation to happen. On very simple terms, if someone is successfully rehabilitated to a degree, it probably means less damages. Just want to reassure you that's wrong, or at least if you encounter it, it's a lawyer that really isn't doing the best thing that they should be doing for their client. One, we have a duty to consider rehabilitation. It's in a document called the Pre-Action Protocol, which governs the way we behave before court proceedings are started. Two, the biggest problem we have with our clients in making sure that we get the result right is uncertainty. If there are polarised views between experts for the claimant and experts for the defendant, we may get the result wrong for our client. if we've actually accessed rehabilitation and the experts on both sides then have an opportunity to assess the outcome, say how it's gone, say what that then means, that level of uncertainty tends to reduce, and it tends to mean that we get it right for the clients. That can often mean smaller amounts of damages. That's fine. That's not a problem, so long as we're getting what the client needs. I'll skip over that. And when we're talking about therapies in this, it's all of that list. It's everything that we can possibly think of. Rehab code I've already dealt with, and then I'll just finish on a couple of things very quickly before we start moving into a quick case summary. The rehab code is useful, but relatively limited in scope. What we tend to want to talk to the insurance companies for the defendant about is interim payments, so that they hand over a chunk of the damages at an early stage, gives the client the flexibility to decide what to happen, puts the client at the centre of it, often with the support of an independent case manager, and Hilary's going to talk a little bit about that in a minute. But once we've got past the rehab code stage, or if the rehab code stage isn't appropriate, then the next stage in the case is to be talking to defendants about interim payments to meet the client's needs for a period of time, however long it seems necessary to look at that for. Might be 6 months, could be 3 years, could be 5 years, depending on the circumstances, and then we'll carry on with the case once we've got through that process.
Okay, I'm very conscious of time. I think we've got just over 5 minutes. I was going to run through a couple of case studies, one for a child and one for an adult. What I'd like to do instead, if that's okay with you, because you will receive the case studies in the packs and you can read them at your leisure, is just pick up on a few more themes from this morning and draw those themes into our presentation this afternoon. I think one of the most exciting projects that is underway, well underway, and being led by Alex Ball is obviously the rehab prescription, the major trauma network that we've got now in the West Midlands, and what the part that we can all play in that process. And I think with key people in posts, such as I know there's a discharge planning coordinator in Stoke. I know obviously there's the Headway acute trauma nurse, there's one in the Midlands, there's one in the northwest of England, and there's a few NHS case managers out there now creeping into the service. These are the people from our perspective that can bridge that gap between you guys within an NHS setting, us within what you might call the private medico-legal setting, and also the third body of the private rehab organisations as well. And I think if we can get this communication going around that triangle, if you like, so that it's a joined up process with the client at the very centre of it, it does exactly what we've been talking about this afternoon in terms of supporting our clients and our families towards the common goal that we all want. And it's really just coming to draw on a few themes again from this morning, and those that Phil has already mentioned, about that there shouldn't be and there doesn't need to be the division between what we do within our process and what the NHS clinicians and private therapists do within their process. So I hope that rings true for some of you from your own personal perspective and where you're coming at these patients and this client group from. The case manager from our point of view is a crucial role within the process that we are involved in. But as crucial is the fact that they must be wholly independent, and the decision as to who the client has as case manager is the client's decision, not our decision, not the defendant insurance company's decision, but the client's decision. And they are the person, the individual, that will then facilitate the whole process of rehabilitation, and it will almost always include some element of statutory provision. It doesn't exclude statutory provision at all. We all know that there's very good statutory provision in all sorts of areas, particularly in areas within the West Midlands, and wherever possible, the right case manager who is doing the right job is accessing that, as well as topping up, if that is what is necessary, from private provision as well. So I'm just going to skip through a few slides to let you read those at your leisure when you have time to do so. These are just some of the examples that a case manager obviously might be able to access both from statutory provision and from the private sector. But again, it's a joined up plan, and that's the theme that I want to sort of draw out. And just to finish, I'm going to quickly skip through just wanted to draw on Mark's presentation from earlier. Capacity is, as we know, a huge issue in any case involving brain injury. Some of the complicating factors that we have had recently in a wide range of cases are there on that slide, and we have huge involvement with our Court of Protection lawyers as well. Those of you working within that field will know the frustrations of trying to work with the Court of Protection too. It's an extremely slow and drawn out process, but crucially important that each of these issues is looked at on a decision and time specific basis to make sure that the assessment is done, as Mark was saying earlier, on a round basis involving all of the professionals and indeed family views as well. How are we for time? Nearly there.
Nearly there. Sorry, Mark and Richard, bless them, they're lawyers like us. We can't help but love the sound of our own voice, so that's probably why we've overrun slightly. So forgive us for rushing through a few things. There are a couple of things that I just wanted to mention as well. One of the developments over the last few years, which has been of very great significance to our clients, is our ability to often obtain compensation for them in the form of a periodical payment order. The reason I mention this is because, again, in looking at long-term collaboration with the client and making sure that the client's protected, there's a lot of advantages to it for clients. In the past, the damages were always, or almost always, awarded by way of a lump sum, and we'd have to project into the future how much might be needed for care and case management, and other therapies and other support, and then a formula would be applied to lead to it being a lump sum. And there's a lot of debate even now amongst the legal profession about whether that formula is correctly doing that or whether it's requiring claimants to take unnecessary risks with the lump sum to make sure they've got enough left over. And it's always subject to the inherent problem that it's statistical. It's based on standard life expectancy, and there will always be, by definition, some people who will exceed standard life expectancy, but their care needs may not stop. Very often in those cases now we're able to obtain a periodical payment order for the care and case management, and it's linked to an index which more precisely goes up in line with the increases in care costs annually. It's a great benefit to clients in terms of giving them security and actually enables them to plan much better into the future as to how they want to interact with the other professionals in their case. So I just thought it was worth mentioning that for those of you that aren't familiar with it, that's been quite a significant way forward. I think very much it's something in recent years that the defendant insurance industry as well have also welcomed, because let's be honest, it's a fair way of resolving things. If someone is going to live till they're 120, they're secure. If actually people don't make it that far and die much younger, then the defendants haven't had to sort of overpay. So it's been a very important thing for clients in allowing them to interact with the rest of their team. Okay, well, apologies for the rush, but I know you'd want your coffee. Any questions at all that you'd like to ask us while we're here, or if not, we can quite happily hang around and you can talk to us in the break. No? Stunned silence. That's probably because we rushed so much. Okay, well listen, thank you very, very much for attending and listening to us. Hope you've enjoyed the day.